Good morning and welcome to the webinar, California Employee Data Privacy Requests, CPRA and Employees, Far From Easy, hosted by Ethos Privacy. Ethos is a leading privacy consulting and technology company that partners with clients on their privacy programs, striking the right balance between privacy needs and business goals. Go ahead and please add your questions to the Q&A section or chat, and we will make every effort to address them in this session. This webinar is being recorded and will be available from our blog shortly. If you would like to access the slides being presented, please fill out our short survey at the end of the webinar and just give us your email address. Thanks. So let's get started a bit. Let me introduce you to Grant. Grant Barrett is a privacy director at Ethos Privacy, where he works very closely with enterprise clients on privacy control assessment, design, build, and deployment. Grant brings a unique regulatory compliance and enforcement perspective as a former California Superior Court judge. In addition to being a Juris Doctor, Grant holds both CIPP US and CIPP-E privacy certifications from the IAPP. And the other thing you should know about Grant is that he loves to educate and inform. And so if you have questions, even about this topic or maybe another one, you should go ahead and add this to the chat because Grant absolutely will do everything he can to answer it. And so with that, Grant, why don't you go ahead and hit your first slide, and it's yours.
Good morning. I get my own picture. I'm so happy. Well, welcome, and I certainly appreciate your time today. And we're going to be talking about employee requests and this new kind of workload that we have coming from CPRA. It seems to be unique with the new laws not adopting the same approach, but we have this in California, and it is quite a lift for a lot of my clients. What I want to discuss first is this concept of employee. We talk about employee DSRs, but employees were created by a statutory carve-out. So when CCPA was put in place, individuals or data subjects in an employment relationship with qualifying businesses were exempted. They were taken out, and we all breathed kind of a sigh of relief as we were tooling up for CCPA, because it was quite a lift to do both consumers and all of these employee personas at the same time. But as California statutory law is famous for, it creates a whole classification of rights based on an exception, and that's what happened. So we got the exception. They carved out all of these employee personas, all based on some form of a relationship with a qualifying business. And then they sunsetted that exemption, which triggered this group coming in. So other than the standard notice provision that you had to provide to employees for collection, use, and sharing of their information, the other DSR rights were largely out of scope, but they've come back. So when I look at these, quote, employees, I bucket them into 4 buckets, and that's basically, these are functional buckets. These are because the data repositories that hold the data and the business units that you'll be working with as a privacy professional or a privacy lawyer to master this data and to perform the Dsr processing activities seem to follow these 4 groups. So what we have are your traditional employees, current, and then former. So this is, again, a data retention issue. If you retain a lot of data, then you are going to have to replay or take actions on a lot of data. And so you also have job applicants, and job applicants is a wild card in my opinion, because those job applicants certainly could put a strain on your system. Job applicants also may have their data held in a third party or a service provider from you. You may outsource your initial intake of job applicants. And so you may have to now work with a third party or technically your service provider to get the data or to take an action on the data subject to an applicant's request. You also have contractors, current and former, and you have B2B. And B2B is sticky. So B2B, these are individuals whose data that your company holds, but you have their personal contact information as a representative of a company. So you have their name, Sue Smith, you have Sue Smith's email, probably her company email, and you may have her company phone number. For those of you that may remember a Rolodex, it would be the Rolodex card. So that B2B representative now has rights to ask you what you've kept on them, what personal information you've collected, and or to delete. Maybe they sever their relationship with the company that you do business with and they want to make a delete. So, and then there's this last classification, which are dependents for benefits and emergency contacts. So these are individuals that you have information about, but it's primarily delivered to you from the employee themselves. So your employee gives you their spouse, your employee gives you their dependents for the purpose of signing up for benefits. Also, you have emergency contacts. So they'll designate someone to be contacted as an emergency contact. And as just a stray issue, it's kind of interesting if that emergency contact makes a deletion request. So there are definitely issues to tackle here, but this is how I break down employees, and it's not simply as simple as you might think, which is, oh, it's just an employee. No, there are all of these individuals. This is how I generally think of processing data subject requests. So a Dsr processing flow. From this employee perspective, you have these different classifications of individuals. And the reason that I've broken them out again into these 4 groups is you're going to have additional issues here. Oh, I see I have a question. Let's see. How is a B2B contact different from a customer, sales lead, marketing lead, prospect? Oh, those are a lot of different categories of individuals. I like that. So B2B is not a customer. So again, think of these data subjects in their context, in the relationship to the business. Think of them that way. So a consumer has a kind of a relationship, an employee has a kind of relationship. It gets pretty tricky if you're a large enterprise, and so your employees also may be your consumers. They could make you could have an employee who's making a data subject access request, but in the context of their consumer relationship. So I would encourage you to think of categories of data subjects in the context of the relationship to the business. Is it as a consumer? Is it as an employee? I mean, you could technically on these individuals here, you could have someone who's was a contractor, applied for a job, became an employee, separated from employment, and you have all of their dependents and emergency contacts. You could have someone, and also is your customer, bought things from you. They could have 5, there could be data sets based on those relationships, and how you tackle this has a lot to do with how you operationalize these DSR rights. And what I would encourage you to do is make the data subject declare their relationship, right? You don't declare it for them as a business, you make them declare their relationship. I am making this request as a consumer, as a customer. I'm making this request as an employee, as a job applicant, as a contractor. That's the data set that I'm interested in you taking action on. And that becomes very important at the intake stage, where you inform the data subjects of their privacy rights and you guide them to the designated intake channel. And I would encourage you to think about those intake channels as swim lanes for each of the personas, with consumers having their own swim lane. You're using the same basic tooling and you have the same basic steps, which is inform them of their rights, guide them to the right intake channel. You also, of course, have to provide a couple of methods for intaking. One is an electronic form, either email, which I don't encourage because of the ingestion of unstructured data along with the request and the need to kind of get into a continuing dialogue, or some form of a structured, like a web form, where it's a fill in the blank, you ask a question, they provide just the information you want. You don't want someone attaching a photocopy of their passport or driver's license if you don't need that information for this. So there's the intake section where you're going to provide them a landing place to make the request. And then there's a critical next step, which is you need to verify the request. And of course, as you know, under CCPA and CPRA, the business's obligation is triggered upon receipt of a verifiable request, meaning a request that's capable of being verified. And the problem there is that creates the 45-day timer, right? So if you receive a verifiable request, let's say through email, someone says, I'm Sue Smith, and I'm your customer, and I want you to delete all my data. Well, you probably don't have enough information just based on the fact that you've got an email address and a name to say that you've uniquely verified the identity of Sue Smith, nor are you sure of the 3 Sue Smiths that you've got in your database, which one you're supposed to take action on. Now you've got a problem because you've got a verifiable request, but the 45-day timer is started. In the employment context, you definitely want to know, is someone applying as a job applicant? Because that is going to be different. You also may have capabilities at the verify step in that number 1, data subject identity verification. You may have the ability to uniquely verify the identity of an employee because they log into their employee account. Voila, you're done, right? The issue there is, do former employees have the same login ability? And if not, how are you going to verify their identity? Do job applicants, maybe job applicants log into a third-party service provider that you've hired to take your job applicants. So they could log in there, but you're going to have to be able to redirect them essentially from your privacy notice to that third-party provider, or at least inform them that's where it is. But you're still going to need to work with that service provider if you're going to use them as the login to verify identity. You also have an issue with contractors who may not have login, maybe on site providing, like electrical work in a business at a business location. So they may have no online profile. You need to verify their identity. B2B representatives, that's going to be an interesting one to verify their identity. And then of course you have employees. The dependents for benefits, often you can have them log in again to a service provider like your dependent provider, which may hold all that information, but you're going to have to work with them. And then you have emergency contacts, and that may simply just be a list in a manager's drawer of names and telephone numbers. So you need a way for each of these personas, each of these categories of data subjects to verify their identity. And that may be using a third-party identity verification service as a plugin behind your web form. Or it may be that, heaven forbid, you have to have in-person communication through your call center or call them back and test them. Especially if you're accepting email DSRs, you may not get all the information you need, and you may have to chase them down with the 45-day clock ticking. As you may notice, I'm not going to give you a lot of pat answers because everyone's tech stack and relationship set and data handling practices and business units, levels of authority and concern in these areas are different. So I'm going to do a lot of kind of issue spotting and letting you know the kinds of things that you have to tackle. But you're going to have data subject identity verification. You also have a separate issue, which is system data validation. So again, we get back to 2 Sue Smiths. So let's say that you have 2 employees named Sue Smith. Someone, if you have a logon for your employees, a secure password protected login, you've accomplished presumably 2 things: verified that you've got the right employee, you've got that employee, and you know which of the two Sue Smith's data to look for. But if you don't have online login for all of these personas, there may be specific information that you need from the data subject to find them in your system. This may be things like date of birth or location. Where's, let's say that you're dealing with a contractor. The validation data may be at which location are you providing service, or who is your company manager that you work with, so that we have some additional data point to find them. And you want that up front. You don't want to have to chase that with the timer running. So in your intake, you want to get the information necessary to verify their identity, and you want the additional information that you may need for validation. You don't want any extra data because, again, you don't want to hold more PI than you need. But you're going to need those two things. How do I uniquely identify the data subject, and how do I link them to data within our systems? The third issue is you now have seen probably in your privacy inbox the rise of the privacy agent or third-party requester. You also have attorneys who could make a request with a power of attorney. You have spouses who may have, you know, a conservatorship or guardianship. You have individuals who can make requests on behalf of another, and you're going to have a way of reviewing their authority to make the request and still have to verify the identity of the data subject. And this is tricky, especially because California has frowned on my favorite solution to this, which is a notarized declaration. So they say that for a notarized declaration, you have to essentially reimburse them for any costs associated with it. So that puts you in kind of an interesting issue if you get someone who's coming with a power of attorney. And so they're coming in and you're saying, well, you need to fill out this declaration. And this is obviously going to create an issue. So that kind of third-party requester, often I'll use a notarized declaration as my first line of defense for someone who comes in and says, I'm making a request on behalf of Sue Smith. I'm authorized to get her data. Give it to me. I will give them the form notarized declaration for them to get Sue Smith to sign off that, yes, John is entitled to Sue Smith's data, and this is where she wants it delivered. The next issue is, of course, you need to have a tracking system. Generally, all of these can go into your same kind of ticketing system, whatever it is, where the data subject, once they've gotten past identity verification and system validation, that's when you let them select their privacy right. You don't intake a DSR until you've gotten their identity verified. Allow them then to select their access, delete, or correction right. And that should create a DSR ticket, some kind of logging system within the company. That ticket is then most likely assigned out because, frankly, I don't recommend over automating a lot of these processes. We don't know what kind of traffic your company is going to get. So while it may make sense to automate the data pull for like employees, and it may make sense to work with your job applicant records, especially if it's a service provider or employee dependents for benefits, those I would not encourage you to over-engineer, at least at the beginning, until we see what our traffic is, especially because the other states don't seem to be following suit with this right. So you're probably going to have a manual search and pull kind of operation, but I would highly recommend that you automate the front end so that you're not ingesting bad requests that are causing you problems. Then you have the DSR processing, and DSR processing is the last one, and that generally follows 4 actions, right? There's usually locate the proper data set that's in scope, do some kind of activity, like for an access report, you're going to stitch the report together from the various data sources, put it into a common report template, because remember, it has to be understandable. You can't just return a bunch of computer code. So you're going to have to sometimes interpret the data for the employee or the job applicant or the contractor. that report then has a format. The report is then reviewed. I generally encourage it to be reviewed. In this context, like an employee's report should definitely be reviewed probably by HR. While they may not do the data location and they may not do the report stitching, having an HR representative do the review before this is delivered makes a lot of sense to me. And then there's the actual effort of report delivery, how you message that to the data subject, and logging the actions taken. Deletion, same concept. I recommend usually the companies build a data deletion framework or some kind of SOP that incorporates like the company's retention schedule and looks at the exemptions for deletion, because there are a lot of good exceptions from deletion that allow you to keep records and not delete all of them. And so it's important to have a good framework for that. You should have built that for your consumers also. Then usually what's going to happen is if there are data deletions, if there is any non-exempt data, then that needs to be deleted. You need to push not only internally where those deletions should occur. And deletions, again, are usually based on use, interestingly enough, right? You may be pushing a deletion signal to your marketing team, but not to, let's say, your sales team, or however you want to look at it, the team that records transactions. You may keep someone's personal information. It's qualified to be kept for transactions. Same thing with employees. You would keep the employees' data even though they've requested delete because you have an ongoing relationship with them, or you would keep them for your legal retention period after termination. So if there is data subject to deletion, CPRA has a downstream notification requirement too. So you have to push to third parties if they're, and service providers and contractors, if there is data that needs to be deleted. Then again, there's messaging to the data subject and logging the actions. Correction is quite a sticky wicket, actually, because there are a lot of unanswered questions and the newly formed regulatory agency hasn't released good guidance, and they've been delegated to provide us some guidance on that. But generally, you're going to have reviewing the request and finding the data that's requested to be changed, looking at that data, and then either grant, deny, or redirect the request. I'll talk a little bit about that later. There's data, the actual data correction, and then messaging back to the data subject. So this is kind of the life cycle of DSRs, and it follows the same basic path as consumers. It's just they're different data repositories. I wanted to share with you a little, some issues or considerations that I think that you need to look at in your context. So for access reports, remember that under CPRA, it's the PI collected about the quote consumer, and in this case, it'll be those employee personas. So it's PI collected about. So when they make an access request, you have to display all the personal information that you've collected about them. There's a distinction you can see with deletion. Deletion is PI collected from the consumer. So there is a distinction in the scope of an access request versus a deletion request. And of course, correction focuses on inaccurate PI. And there are a lot of unanswered questions here, but the bottom line is the information inaccurate? And inaccurate, actually, as you dive in there, is both incomplete or incorrect. That's how it's described within the statute also. So there are some questions about what you can correct. If you have data in your records that truly reflects an event that occurred, even if the event itself was a untrue fact, you may still refuse to correct it if it's an accurate record of what happened, even though what happened, the underlying fact may be untrue. So there are some interesting issues that we have to address and that I'm hoping we get a little more clarification on. There is, of course, experience under GDPR because rectification has been in existence. So there are lessons learned from our GDPR colleagues. Going back to the access report, remember that it needs your report and its contents need to be easily understandable to the average consumer. So often you're going to have to do a little bit of data translation or explanation in your report. There's this issue of that the report itself needs to be transmittable and, if available, machine readable. So that may be CSV. That I see a lot of PDF reports, and then but there is also the issue of, do you want to give them the option to get it in a CSV format? That bumps up against how you deliver the report. Right? Are you going to apply password protection to the report? You should, especially if you're going to send the report via email because you don't have an existing online account to deliver it. And then you have a little issue with the password. If you password protect the report that you're sending, which you should, how do you get them the password? You wouldn't send it in the same email. So you have an issue about delivery of that password if you're going to password protect an access report. And this is especially important where you don't have an existing online account to deliver that report within. Deletion, again, you should find your company's retention schedule, and this is your best friend in the deletion area. You also, of course, want to rely heavily on lawyers' interpretation of the CPRA exceptions, and there has been a change in the exceptions since CCPA. They took away one big exception that kind of swallowed the rule. So generally what you're going to be able to retain is PI necessary to perform the employer-employee contract, things for facility and online security, and then to otherwise comply with your legal obligations. But I'd encourage you to look at that 1798 105D for your list of exceptions, because you'll probably find that a good deal of the data that you're holding is exempt, as long as it's timely. If you're in a position where you've kept every job applicant, and their resume and notes about them, and your company's 20 years old and you have all of that, you may have a harder time asserting any exceptions there to their deletion request. The downstream deletion signals to service providers and third parties, that mechanism itself can be challenging. That, of course, brings up the whole issue of, do you have a contract with all of these individuals or companies that are holding data of your employees or data subjects in this employment context? And then the last one is, of course, the interesting caveat that you may retain personal information necessary to prove that you complied with the deletion request. So someone asks you to delete all their data. If you strictly applied that, you might end up with no data in which to defend a claim that you didn't delete the data. So you just recall that in your logging, now, of course, access to that and not letting that information leak back into your general systems is going to be very important. On the correction, there are a lot of questions. Are you going to require proof of inaccuracy? How would you receive such proof? Are you going to ingest birth certificates, court orders, newspaper articles? How many elements can someone correct? Can they correct both their first and last name? How about their first, last name, and their date of birth? What about their gender? There are a lot of questions about this, and whether you're going to receive proof, and then the ingestion. And anytime you open up your system for ingestion of additional kind of extraneous PI, you have a caretaker role that you have to exercise. So now you've just taken a bunch. So at this point, what I've seen are that there are often existing processes that companies have to correct their data. And to the extent that there's additional information required in those processes, we'll often use those processes. And you may end up redirecting your data subject to that existing process to complete it, because additional verification or extrinsic evidence is going to be required to make those changes. So you're going to have correctable personal information that requires no additional evidence. You're going to have correctable, but it requires additional evidence. Then you're going to have stuff that's just frankly not subject to correction. Often a good place to start is look at all the PI in the access report for each of these personas that you would turn up, and then determine which of those elements is subject to deletion and which of those elements is subject to correction. And if it's going to be correctable, does it require extrinsic proof or not? And is there an existing process that you could redirect the employee to, especially if it requires extrinsic proof? You also have, for correction, the whole issue of decision making. Who's going to make the decision on a given element? How you communicate denials. And the consumer has the option to then record a 250-word addendum to their records if you don't correct as they've requested. So that's an interesting challenge, and how you accommodate that. And again, we're waiting for regulations from the new California Privacy Protection Agency, which their sole mission now, instead of an attorney general's more broad scope, this agency only has one job, and that's privacy. And so we need their regulations. That should give us some good guidance. That's what we're hoping for. But the bottom line on this one is, if I was going to take a shot on it, I would say things like, how many data elements can be corrected in a single DSR? I'd say one at a time. That way, if you're going to grant one, deny one, your ability to log and report your metrics that, of course, CCPA has is clear. And it gives you a little bit of scope. If you just allow open-ended correct 15 things, you have quite a difficult task ahead in the correction. What we're hoping is that correction, it does not see the kind of adoption that, let's say, data deletion did, and we don't have to tackle it, but it is a mechanism that you're going to have to build for, and there are a lot of unanswered questions that we're all struggling with. I want to move on now to some supporting activities that I think that you should consider. The first one is general mapping. Most likely you're going to need to reach out to HR, payroll, benefits, contract management units in your business for each of the employee types that we've listed. That you're looking for the personal information elements that are collected. You're looking for data validation elements, asking them, if I have two Sue Smiths in your system, how would you tell one from the other? That's your data validation element that you need to get up front. So you need to ask that of all these entities, whoever's going to essentially be your lead for each of these personas, who's going to take action on the data. You need to know where your personal information is actually stored. That will often lead you to which IT or InfoSec partners you're going to need in order to operationalize the data location and return. You should have a good understanding of the uses of PI, because this, of course, will support any exemptions to deletion based on the use of that personal information. And you should know which PI is leaving your company, either going to service providers or going to third parties. That's important both for your disclosures and for those downstream signals. The importance of contracts is becoming more and more important, as we're seeing almost all the new evolving laws in the United States now are requiring that you have service provider and third-party data sharing contracts that provide certain protections. So in this process, it's also a good idea to confirm that all your service providers and third parties that are receiving any of these personas, employees, job applicants, contractors, are bound by written agreements restricting the use and their sharing of the personal information. And also there are provisions within these laws where they are to assist you with DSRs, which can be essential when you're dealing, if you've outsourced like your job applicants and or your benefits, having a provision in the contract that they assist you with DSRs can be a lifesaver. The DSRs themselves, of course, you are going to need a way to verify identity. And this is important, of course, because taking action on data, especially sending out an access report without properly verifying identification of the data subject or of the requester and making sure they're the data subject is an issue. And I'm not even going to say the B word that gets attached to this, but you do not want to send out an access report without having confidence in your identity verification process. Data validation, again, is critical, often overlooked, but you want to make sure you're returning the right data subject's data and taking action on the correct data subject. Your communications, look closely at your communications, all the way from intake to acknowledging receipt to how you handle any requests for status or update. We've seen often the call center will get individuals who are having trouble with your intake mechanism, how to recognize that issue and be able to receive those requests still in a verifiable or in a verified form is important. So working with, your call center representative, is often good to have someone designated or have a group designated as your privacy team within it, where any of those calls where someone's having trouble can go there and they can capture the necessary information in that call so that you don't have to chase after a data subject. And then making sure that you have good DSR tracking and logging. Those are important. Finally, you have the updates to your notice. So presumably November or December of this year, you'll be working on getting a publishable change to your privacy notice to explain to your California employees and those other personas how they can exercise their privacy rights and what the methodologies are, making sure that they're ready for those plugins. So those are some supporting activities. Now, I don't want you to be overwhelmed by this, but this sheet kind of goes through at a little higher level of detail, that very first slide, right? You have the intake, you have online intake, and often what'll happen is when you're running your project, right, you'll have a list of these tasks, you'll have solutions, and I've thrown some kind of hypothetical solutions in for each of the tasks. And then you're going to have your stakeholders, who you're going to be working with, like e-commerce or IT, who's going to be owning this, who are the teams. And I show this to show you the kind of the level of tasks that are going on, the different teams and the issues that they're working on, that this is something that you really need to work on. Now, hopefully you have your consumer processes to rely on, and hopefully for at least the upfront part, the intake and some of the verification processes, you may be able to leverage, and you've got lessons learned from CCPA, I am hoping. But again, I don't intend to oversimplify because the employee process is complicated. So my recommendation for Dsr intake is direct to a structured web form. Hopefully you have the same thing for your consumers, not using email, you're using some kind of structured intake, that you have call center privacy reps available to take in calls as your alternative basis, that you have an identity verification process or a service provider for this. The same as for your consumer DSR pathway. Now, again, you may have subsets like current employees that can log on, but the other personas won't be able to do that. Most likely, you're going to need an identity verification process. And there are service providers that do that, but you'll need to be able to plug those into your solution. You need to know what additional data items you're going to need to uniquely validate a requester's data in your system. That may be the employee number for employees. It may be date of birth or last four of Social Security for contractors, maybe dates of service. So you need to find out what those are from the stakeholders who hold the information so that you can ask those questions up front. You're going to need to have a way of dealing with third-party authority. I call it OBO because that's on behalf of. Those are people who make requests for on behalf of. You need some form of a way of handling an authorized representative. And you're doing two things there, right? You've got to verify their authority to make the request, and you've got to verify the identity of the data subject. And of course, you have to validate that data subject's data. So you have all of it with an OBO request. So those can be very complicated. And I use a declaration form for that is my usual recommendation. So with the access, right, you're going to have some team automating a search, or maybe it's a manual search for the personal information that you've identified that's in scope. You're going to stitch the report. You're going to have someone, I would recommend HR probably, reviewing the final report for employees and other employment related personas, just as final eyes before it leaves the building. This for consumers, I often recommend that the call center has a privacy representative who reviews the report as last eyes on it, because they generally know what their customer data should look like. And then you've got to get that report to the employee with password protected, some password protection, and you've got to ticket and log all your actions. So again, for deletion and for correction, you follow the same basic path, right? For deletion, IT is going to find the data in scope. It should be reviewed against some form of a data deletion framework or an SOP to designate the data that is in scope for deletion per persona. I often have an extra step in it as an extra protection. In this case, it's HR reviewing and actually performing the deletion that's recommended by IT, and then messaging to the data subject and logging actions taken. Correction, at this point, with all the unknowns, I'm relying heavily on the expertise of our HR representatives for this, which is that when the request comes in, it generates a ticket. HR is going to look for the PI and scope, be the lead business. It may have to go out to other businesses to find the information. HR is going to review the correction request and any evidence and make sure that the PI requested for correction is in scope. So you're going to need an SOP for that. And then the takes action to correct any PI that is appropriately correctable, and then messaging back and logging. So all of those are kind of the steps. Now, what I will tell you is that I am the happy recipient of the product team at Ethos that has just given me what if functionality on our platform. So I just took a little screenshot. I was working with a client. In this case, I made a fictitious business, Widgets Are Us, that had complied with CCPA, has California employees, and what is the impact when CPRA comes in? I apply the California Privacy Rights Act framework within the tool, and it pops up and tells me, oh no, I have 43 new requirements, that I have 8 unchanged requirements. So I don't have time in this presentation to go into that, but I will tell you that all of the time that I spent in spreadsheets and tracking and doing delta analysis for the various laws, my product team has just answered my prayers. And now I can simply apply to a given company's context a new law, and it pops up all the new requirements and or requirements that have changed a little bit. Like you may have GDPR compliance, so you're doing things within 1 month, and now you have a new requirement, which is the 45 days. And so what are you going to do about that? Well, you'll probably stay with the month to take them most strict, but you should understand the distinction and understand if you want to make any change or distinguish between two requirements that may apply to the same right. So this is a great, wonderful thing that was just released to me, and I just wanted to share my joy. And with that, I have a couple of minutes left. I'd love to take questions from anyone. I can go back over stuff. I know that I covered a lot of ground and a lot of issues.
Grant,
yes.
there is a question here. I wasn't sure if you answered it earlier, but would you also recommend requesters submitting requests based on these different personas, even though the fulfillment process may not be automated? What if I was an employee who's now a contractor for that company? So I think you kind of covered that.
So let me see. I'm sorry. So I would definitely have, let me go back. Don't watch so you don't go crazy. There you go. I would definitely have the requester designate in what capacity they're making the request. So if they're making a request as an employee and they want their employee data set versus a job applicant, or let's say that they were also a contractor before, I would have them designate it. If you're making your request in the relationship with the business as a contractor or former contractor, click here. Or you may have radio buttons on a web form. You may have a drop-down list for them to select. You may have independent links for them to go in. Heaven forbid, but you may have different email ingestions. But the main issue is each of these groups is generally going to have different data validation. So when you look in the verify section, that number 2, that system data validation is probably going to be unique to the category of persona. So employees can give you an employee number. That's great. A job applicant's not going to have an employee number. So how are you going to differentiate between 2 job applicants or 2 contractors? And of course, you don't want to take in a master list. Oh, well, if you have an employee number, give me an employee number. If not, give me your last 4 of your social, or your date of birth, or, you want to take in the least sensitive PI that's necessary to validate their data. So a one size fits all is probably going to end up with you taking in a laundry list of data, and still you have the added complexity of now, if I'm going to return, I find their data in the contractor, job applicant, and employee systems. And am I going to return all of that data? Is that what they want? Am I deleting all that data? Because the access and delete questions are kind of an all or nothing. Correction is element specific, but access and delete are not. So I'd strongly encourage you to build your system with these swim lanes for if someone is making their request as a consumer, you give them their consumer data, even if you happen to have them as a contractor, even if you happen to have them as an employee. Plus, you'll be looking in different systems. You'll be triggering different business units to take actions on data. And you don't want to send out a company-wide blast. Anybody with Sue Smith's data, send me an email. That's not a great way to handle it.
So Grant, I think we have time for one last question.
Sure.
What would you recommend companies who are subject to GDPR have existing manual processes, maybe not perfect, but no personas? What tips or a few steps would you give them to mature their process?
Well, and that's a great question, because of course, GDPR doesn't recognize kind of personas the way that California or now, Colorado, Utah, Virginia do. Under GDPR, as we know, there's only 4 things in the universe, right? Data subjects, controllers, processors, and regulators. That's all. You're one of those 4. You could be multiples, but again, in your context, you're one of those 4s. And we're taking data subjects and breaking it down into customers, or, I mean, they're all consumers, but there are customers, and those who are making a request in their relationship as a customer or in the context of the customer. And then there are these others. And this is really this distinction that I draw and that I would encourage for is because this right isn't going to proliferate. Not GDPR, it applies to all the EU, right? You're a data subject. A data subject could clearly be a B2B, a contractor, job applicant, employee, customer, anything. And so I think that it's appropriate to give the data subject the option to make a request. Now, they can make 2 requests per persona type. So that's the trade-off. If you start to break this down into, are you making a request as an employee or as a job applicant or as a contractor? They could make 2 per year per persona. You can't say, oh, well, you get 1 as a job applicant, 1 as a contractor. So now you can't make 1 as an employee because you already asked for your 2. You have to give them their data twice a year. So if you're going to break it down to the way that I would empower both the data subject to get the specific data they're after, because they may be only after their consumer data. They're not after their contractor or employee data. And they don't want all that deleted. And so I think that it's a rational and appropriate way of going at it. But if you're going to do it, then you have to deal with that at the intake stage and the notice stage. You have to let them know, all right, you may have multiple relationships with our business. You may have a relationship as a customer, as an employee, as a contractor. And we want to take action on your data as you request. So please designate in what relationship status are you making this request, and have them ingest it that way.
Okay, Grant, if you could go to the last slide, please. And then we'll
Sure.
just mention to
Sure.
folks
Sorry.
that we do have another webinar that will be coming up. And maybe this isn't the one that's the ticket for you, but maybe you have a friend who's just starting off in privacy, who gets assigned this fabulous role. And this is going to be their launch pad for success. So we'll have more information for you about this on LinkedIn as we put up the Zoom link for it. I want to thank Grant very much for his participation and for all of your attention today. Have a great day, and we'll see you later.
All right. Thank you. Thanks for attending.